Hello, fellow splitting geniuses. Welcome to another episode of Splitting Smart, where Heather and I get to have candid and informative discussions with divorce and well-being professionals, which is very exciting. And our mission is to provide you with knowledge on various modalities of support that can help you unhitch with fewer hitches. So I'm Lila Aiken Ali, a divorcee, a divorce coach, and the founder of Split.fyi.
And I'm Heather Steer, also a divorcee, a divorce coach, and a certified divorce financial analyst. And I'm just going to point out a couple of things for technology. If there's any questions throughout our discussion, go ahead and throw them in the chat over. If you go to the bottom of your screen, there's a little chat function, and I'll be monitoring that. And specifically today, if you have any words or terms or questions that you want answered that, or any confusion over what we're talking about, then throw those in there as well.
Great. So without further adi, today's guest is has been in the past one of our most popular webinars, actually. Jodi Silberman. She's a paralegal and has been a paralegal for over 27 years, a founder of Just Call Jodi, Inc., and From We to Me, her divorce support coaching program. Today, we're going to be discussing, in today's topic, we're going to go over a little bit of the stuff that we talked about in our last webinar, like the difference between a paralegal and an LDA, which is a legal document assistant. But other than that, we're going to go down the path of divorce terminology, vocabulary, abbreviations, what you find on your files and your forms and all of that. Is super overwhelming. So welcome back, Jodi. It's good to have you.
So exciting to be here. I love being with you ladies.
And yes, I think this is such
and spread information and help people. And
it's the most overwhelming, I think, experience because unless you're sort of versed in the legal jargon, it's super difficult to understand what things are being thrown at you. And lawyers like to talk really fast.
They do, and they have their own little language that they use, and they don't like to explain themselves either.
and they take for granted because that everyone understands it because they talk this language all the time. I find that I have been guilty in my past lives of doing exactly that as well. And there's initials, there's acronyms, there's these words that for us, it's everyday lingo, but for people that aren't in family law on a regular basis, they're like, what? Or in a court system, or
you almost take it for granted. For a real quick on it, for instance, like a process server, I take it for granted that people don't really know what that is, because if you're not dealing with it in your daily life, why would you? But we do. So you think it's just something that it's common knowledge, and it's not.
No,
it isn't.
No.
It's not. It shouldn't be.
No, and thankfully, I was just gonna say that. But it really, when you are trying to just get up to speed and understand your divorce, at all, this is just one of those things that if we can take a little bit of the fear away or start familiarizing people with some of this lingo, I think it's really, really helpful. So it's not as foreign, the second or third time you're hearing something. And to our audience, you may not retain all of the information we're going to share today, but hopefully it will make you more comfortable. The one thing I will say is always stop your attorney or your divorce professional that you're working with and ask, don't be afraid to say, hey, I'm not following you. Because I feel like sometimes we have an ego that you want to sound smart and together in front of these professionals, but this isn't your profession. You're hiring this person because they're the professional. And so slow them down and ask the questions.
So Jodi, let's off the bat, and we can start diving in. Could you tell us what the difference is again? And I know we've gone through this before, but between a paralegal and an LDA and their roles and how those roles can really help support someone who has, whether they have legal representation or not, just the roles between them.
The big difference is a paralegal works under the direct supervision of an attorney, and a legal document assistant is out there. They can help the general public. They've been vetted by the county. We have to meet the educational requirements of paralegal education experience, and then we have to present that to them and get certified and carry a bond so that we can help prepare documents. The difference is we can't give legal advice. So what we can do is we can take our knowledge and experience and the legal procedures and educate you to that. We just can't apply it to your particular case. I can't say to you, oh, you know what, he's making $100,000 a year, you need to go file for spousal support. I can say the court allows for spousal support, and in the past, when there's a vast disparity in income, there's an option for spousal support. These are your options. Which one do you want to choose? And then we can prepare those documents, and then the legal document assistant, because we're familiar with the procedure and the forms, we can get it prepared and put together in a manner by which, number one, the judges like to see, and that will get through the court without getting kicked, and also have the hopefully desired result, or as close to that desired result that you're looking for.
Right. So can you walk us through because that's an interesting, I think this is one of the biggest and the scariest things is like, what do I do first?
Yeah, that's exactly
right?
what I want.
And right. And it's like, I know there's all these forms, which are overwhelming. And I know these are particularly California specific, but there is a protocol anyway to divorce around the world anyway that you have to do. So could we go through like the petition? Somebody has to ask for the divorce. So let's start with that.
Yeah, I like to break it down. There's really 3 stages of divorce. Okay. That's it. There's the beginning, the initial stage where to start it, you have to file your summons and petition. And if there's kids, you have to file what's called, we refer to it as a UCCJEA. It is the Declaration under Uniform Child Jurisdiction Enforcement to Minors Act. And that's a mouthful. That's why we say UCCJEA.
and the UCCJDA is a national
It's a national form.
Yeah, because that is not a state. Yep.
It's on, and support is on a national level when it comes to violating orders for children and taking them out of state and doing those things. That's what this is. This gives the state court jurisdiction over those children. So your petition essentially just notifies the court that you're starting a case. Mm-hmm. I get a lot of people that misunderstand, thinking that when they file that and they check that box support, or they check that box for custody, they are going to get a hearing. They are not. All this does is it says, court, I'm filing a lawsuit, and I'm filing a lawsuit for divorce, the breakdown of a partnership that we refer to as marriage. Then that has to be personally served on the other party. Once it's served, your legal clock starts ticking. Now they have 30 days to respond, and if they don't, it goes into, that's more definition. We can get into a default or a default uncontested with an agreement, and I can go through the definitions of those.
Define serving, because I think that's a bit of a mystery. You're like, oh, I have to serve. Like, can I just be like, here, sign this? I mean, what?
And people make that mistake a lot. Okay, so service is essentially handing someone documents. However, it has to be someone over the age of 18 that is not a party to your action, meaning it can't be you, it can't be your kids, and I mean, it can be your friend. Generally, it can't be somebody that's involved in the lawsuit. If it's somebody that's going to exacerbate the situation and make it worse, I would tend to tell clients, maybe that's not the best idea. But service in general is, you can have, it doesn't have to, they have people that are called process servers that are, they're professional people finders. That's what they do. They locate people to hand them the documents. When they get handed the documents, that person does not have to sign for the documents. The person that actually is handing them the documents signs what's called a proof of service, and that proof tells the court who handed the documents, who received the documents, what documents they received, the date they received them, and the time they received them. That gets filed with the court. That lets the court know that that it was served, and they're signing it under penalty of perjury. So if service gets called into question, they can call that process server in to confirm that those documents actually were served on that date, on that time, to that person, where, when, what, and how.
Oh, can I ask
So
a question really quickly?
yeah,
Because this is something also people need to understand, and I hear this a lot. Who does that? If they don't have a server and it's a friend, or so you get somebody to do it that you know, who has to do that? To
so
say that right.
yeah, if you don't, if you don't have somebody that you want to do it, or they're not comfortable doing it, which happens a lot, your friends may not want to get involved. So you can hire what's called a process server, and that's what they are. That's what their job is. They are a professional
But
process
what
server.
if your friend does do it? So that's what I'm asking. So let's say I got my friend to do it and she served for me.
Uh,
But then does she need to go and say, so that's something that to finish
okay.
it off, because I have had circumstances where saying, well, I've been served, but the person who served me didn't actually file it and say that
Oh,
they served.
it is your responsibility to make sure whoever you're having serve that paperwork files that proof, prepares, finishes, and files that proof of service. The onus is on you because it's your case. Whether if you have a lawyer, they're going to make sure it gets taken care of. If you have a paralegal or an LDA, they are going to make sure that that gets taken care of. If you do not, you have to make sure it's called a proof of service, and it's form number FL. What is their form number? I have to look. FL.
Service is
I
good.
have it in front of me. I did have it. Hold on. I'll get you the form number. But I think it's a FL. I'll tell you. I'll pull it out while we're talking, and I'll get back to it. But you need to file the proof of service with the court, and that person that you had serve it. If it's your Aunt Martha, you need to have Aunt Martha fill out her name, her address, her phone number, the location where she handed the documents, the address, the date, and the time, and actually every document that she handed her, the name of every document. You don't necessarily have to list the form number.
It's the FL 115 in California.
Yeah.
Thank you, FL 115. I wanted to say that, but I didn't want to say the wrong number, so I wanted to look at it first.
I don't have all of them memorized. I used to have a
I don't
little.
certain ones I memorize, and
There are
that
a
is
lot of FLs.
yeah. So, that's just one I don't happen to have the number memorized. It's like I knew it until I went to go say it. But either way, once it's complete, it has to be filed with the court. Now it has to be filed. Your proof of service of summons, the FL 115, has to be filed in order for you to get a judgment. So at some point in your case, it needs to get filed, whether it be right away or with your judgment packet. It has to be done. So you need to make sure that the person, whomever it is that you're hiring or having do it for you, has to complete that form. And again, the onus is on you to make sure that it gets done.
Right.
Really, at the end of the day.
So talk to us a little bit about also, so that's
Okay, so
the
that's
initiation of the divorce, right?
initiation.
Okay, here we go.
We've
And
completed.
there's always a little bit of misunderstanding of, okay, so when's the date of separation? Like, so that's, and then, you have to fill these out, and it's like, wait, there's a date of divorce, date of separation, date of marriage, date of all these things, DOM, all those abbreviations. But really it's like, how do I fill that out? Because some people say, well, we have been separated. We haven't been really living together. So what do I put on the form? So can we clarify?
Yeah, so this is what I always tell people, or we always tell people: the date of separation is the date that you feel you stop living together as husband and wife.
Okay.
You're probably going to have a date, and sometimes those dates are very definitive, and sometimes they're nebulous.
Mhm.
And sometimes I had a case where it was 10 years in the past because they never did anything. So that it happens. So that was an interesting one. And it's tough because what happens is you have to recreate the wheel from 10 years ago.
Right.
So the date of separation, the date that you feel you stop living together as husband and wife, you're going to put that on your petition. When the other person responds, they're going to have a date of separation. It may or may not be the same date. Okay. Attorneys refer to that as a trial issue, meaning it gets punted to later on down the line. At
Okay.
some point, you're going to have to work out whose date is driving it.
Mhm.
Now, the significance of that date is that any income earned or expenses or debt incurred on or after that date is separate property.
Right.
So if you win the lottery before that date of separation, you have to split it with your spouse. If you win the lottery after the date of separation, it's all yours. So in some circumstances, like one where it's 10 years down the road, that date can be pretty significant. And when you see it in a lot of times in the values of real property or retirement values, they could be up or down. And that's why they give, sometimes you have alternate valuation dates. I mean, this is kind of going down a different road, but you use those dates are important because there's a money value behind them.
Mm-hmm.
There's a value behind them. And so if you have differing dates, then it's a strategy. What date works best for you? And then go with that. Then try and work that into your settlement strategy. So that's what the significance of the date is. So the date that you feel the two of you stop living as husband and wife, just because you put it on the petition does not mean it's set in stone. Your petition is just saying, this is what I'm asking the court. It is not an order. It is not giving you permission to do anything. As a matter of fact, on the back of the summons, it stops everybody from doing anything. Right. Back is what's called, you'll hear the term ATROs, and that's automatic temporary restraining orders. So once that other party is served, it's a game changer. All those things we're doing as husband and wife and selling it, you can't do that. Now you can't go selling assets. You can't spend that. You can only for necessities of life, your roof and food and health. Other than that, you can't go sell. You can't cash out your retirement. You can't sell the house. You can't sell the car. You can't do. You have to get insurance in place. There's a lot of things that the games, you can't go playing games is what it is. It's to stop people from playing the hide the salami game. I mean, it happens, but that's what the intent is behind it. So once that's in place, everything kind of freezes.
And this is an interesting thing because what if two people they're separated, but they're living in the same house?
Happens a lot, actually.
Okay. Is there a form for that? Is there something that they have to say? It doesn't change anything. Okay.
No, the only difference is because it happens a lot. Number one, for economic reasons.
Right.
The one thing is, though, the court won't make orders for support if you're all living in the same house or custody. If you're all living under the same roof, you can file, because the intent to file is a legal perspective. It preserves what's called retroactivity, meaning the date by which your support starts. Because when you file your petition, it doesn't do anything more than just gives the court authority, jurisdiction over those orders. It gives the court authority to make orders over every box that you've checked. If you haven't checked the box, the court can't make an order on it.
Interesting.
So even if you don't think you want spousal support, you should always check the box, because you don't know. Because you can say no, but if you don't check it, then you won't get it. I mean, it's just they have no authority to make an order about it. So everything on that petition is what's giving the court authority to make orders or judgments in your marriage on those issues. So all that petition does, and then the response, once it's served, responds to that petition, and again gives the court authority responding over those issues. It doesn't give you a hearing date. It doesn't give you authority. It doesn't do anything more than open a case with the court and give the court authority over those issues. Okay. So that's step one. Step two is the financials. This is where it's like the meat and potatoes. This is where all the fun stuff and everything happens in between. This is where if you need orders, you can file it used to be called an order to show cause. It's now called a request for order.
Mm-hmm.
And you can
that also is an RFO. So you'll hear
RFO.
And you file a block.
RFO.
And when you file your RFO, if you're looking for support, you have to also file what's called an I&E, your income and expense declaration. So, and that falls in the financial disclosures section. California is full disclosure. If I go off somewhere and you need to pull me back, let them just holler.
And I think where we want to go is just making sure people understand the definitions and the acronyms. So things like DOM, date of marriage.
Date of marriage.
Like you'll be reading a questionnaire from your attorney It'll be like DOS is date of separation.
Right.
DOM is when you got married, when it was, legally married. Then
DOD is date of divorce.
increment expense. Yeah. RFO, request for orders.
The RFO, the request for order, TRO, temporary restraining order. You hear that a lot.
And those could be financial, to your point earlier, or they can also be physical.
Mhm.
Correct.
So, but there's in California and most states, actually, you do go into some restraining order, financial restraining orders, while your case is getting sorted and all the assets are being identified and debt.
Right. That's what, and even in any lawsuit on the summons, it prevents those certain, it's prevents certain things from whatever that issue is, from people just don't touch that. Now we got to figure out what that mess is.
Yeah.
That's kind of what the point is. So those are the outros, and they're actually really important, and they're on the back of the summons. So I think, whenever you get served, that's, if you're going to read anything, pay attention to the back of the summons. What else? So, an ex parte, which is an emergency hearing. And you will hear, if you have some kind of an emergency, you have to get into court right away. You'll hear your attorney mention that. And that is the term to get for an emergency hearing. You have to give notice, and there's a procedure for that. So there's ex parte, and then
giving notice is giving notice to the other party that you are going to go into court.
Call somebody, not you, again, somebody over the age of 18. It's always over somebody over the age of 18 that's not a part of your case, no matter what. Whenever you have to either serve something or notify the other party. Any court case, both parties have due process, the Constitution. So everything is full disclosure on both sides. Nothing happens. There is no Perry Mason smoking gun. That doesn't happen. It's whatever you file with the court, the other side sees everything. And there's, so, I totally lost where I was going with that. When you file the
ex
parte, you have to tell the court, the other side, you have to give them notice. Somebody has to call and say, hey, I'm filing an emergency hearing for XYZ.
Right.
And tell them when, where, and then you have to give them an opportunity to say, I can't go, and then provide them the paperwork. It's a short window. It's like a 12-hour notice that you have to give them so that you can get in. And then the court decides whether there's what's called exigent circumstances, which is emergency circumstances or extraordinary circumstances in which somebody's in danger, there's harm, or extrinsic harm, like immediate harm to you or to the other party.
And this could be like, I can't pay my rent unless I get some sort of distribution.
No. That's my next thing. The court will never grant an ex parte over money because everybody would be there on an emergency. So support, the court does not consider ex parte. It's usually over kids or safety, or something like that. Or, if if there's a house and they're interfering with the sale of a house or a contractual obligation, if you're looking for support or you got to pay a bill or something like that, it's not going to happen. The court won't grant it. I mean, in my experience, the court doesn't see support as an emergency. We all do, but the court does not.
Right.
So they can be wonky. I mean, I've seen them grant some things where you're like, that's never going to get granted. And I've seen them not grant some things that you think would be immediately granted. So, I mean, if you have an emergency and you feel it's an emergency, absolutely file it and see what happens. But anyway, that's an ex parte hearing. And when it comes to support, they don't grant them on an emergency basis, I will say. Now, there's another alternative, which is called an OST, which is an order shortening time. So it's kind of the same procedure, but you can get in sooner than the regular setting of 60 to 90 days out, rather than, oh my God, it's an emergency, I have to get in tomorrow. Whereas you need money to pay your rent. It's an emergency, I can't wait 90 days, but I don't have to get in tomorrow. So I need to get in on an order shortening time, an OST. So then you can get in a little sooner than later. And
these have all the forms that correlate with all of these that you have.
Those all go on your request for order. Those all are a part of filing your request for order. So any time, no matter what, anytime you need something from the court, it all goes on your request for order. So all of these things are a part of filing a request for order. So
Okay.
anytime you need something from the court, you have to file a request for order if you need an immediate order.
So we hear the term discovery quite a bit when you're going through divorce. And at what time, because we went over the beginning stages of everything, right? And so at what time do you start the financial? And so I am taking that, I'm assuming that that's when the discovery kicks in.
Yes. Okay. That's exactly it. Stage 2, the fun stuff. That's when discovery, because you're exchanging financials at this point. You have to do the income and expense, the I&E, the SAD, the schedule of assets and debts. So you have to list out everything you have. So this is that time that happens. Many times there's one spouse that knows what everything is, and one spouse that maybe knows some, doesn't know anything, knows a little. So then there's that time when you can do what's called discovery. And that is a way to compel the other side to turn over documents. Okay. So you can ask in good faith, and it all depends on how well the people can communicate, and also their attorneys and who's involved, or your representatives of, or not your representatives, but the people that you have working with you. There's, if you have to force them to give you the documents, discovery is the process. They have, you can ask questions. They have form interrogatories, which is a form that's set out like the other forms. It has a bunch of questions, and you just check the boxes, and that compels them to let you know their name, their social security number, who's living with them, get them to turn over the schedule of assets and debts. And there's other questions on there of information regarding property, if you had appraisals, things like that. Okay. So if you have to find that information, then you have what's called, you hear to refer to, I don't know, in the legal world, they refer to it as 2031s, but that is a demand for production of documents. And that's because it's California Code Section 2031. And so that's those things that no one ever wants to do. It's this big pile of paper that you get that says, I want your tax returns from the last 5 years. I want bank statements. And they kind of ask for everything in the kitchen sink. I'm going to tell you, most of the time, half the people don't even have the stuff that's in those documents. So don't get completely overwhelmed with it. If you have it, turn it over and get it, because they're going to get it one way or the other. It's going to make your life easier. And if they don't, then, then there's subpoenas. You can get a subpoena. If they don't turn it over, you can go to the bank and you can issue a subpoena, which is signed by a judge, compelling them to actually turn over bank records and things like that. And then there's different forms of subpoenas too. I mean,
when you declare discovery, though, you yourself have to do the same thing. So it's not that when somebody is not, I just want to clarify that for the audience. When you think that there is things missing, and then, out of the declaration of finances, then whatever you're asking for, you're going to have to do yourself. I just
correct. What's good for the goose is good for the gander. I tell everybody that. It's always, it's divorce is not one-sided. It's, again, due process, both sides. Everybody has a stake in it. So everything, what they have to disclose, you have to disclose. And that happens a lot, quite frankly. People, number one, that's what that's what runs up attorney's fees, is discovery. Discovery is expensive, and attorneys send it out as a matter of course, because it's their job. It's part of representing you zealously and representing their clients. So they will send it out as a matter of course, and it's also billable hours. And so then people get it, and the other side, you get mad. Why do I have to do this? Don't they have to do this? I want to do this. Well, yes, you absolutely can do that, but it's going to cost you to do that. And what are you going to gain from it? I always tell what are you going to, principal costs money. So if you're going to gain something from it and you're really looking for something, it's absolutely a necessary process. If it's a tit for tat thing, then you're just spending good money after bad to waste.
It happens all the time though, because
every day,
just to waste the other party's time, even though it's one person typically that has all the information, they will serve discovery back on the one that doesn't know anything.
Right.
Just to do it.
Just because, just a matter of, because they did it. So can I. It's like the the schoolyard mentality.
Yeah. Right. So discovery is between the two parties. So you're serving discovery to the other, to the other person involved in the thing.
Right. And again,
Subpoenas are to third party institutions like a bank, and you're like, or an employer, like you're going to go subpoena employee records. You really want to see what their payroll looks like, what their benefits, what kind of stock options they have, blah, blah, blah. So that's when you have to pull in, you have to do a subpoena.
Right. That's for the institutions. When you go above and beyond, you've tried getting it from the person. Now you got to go to that next step. That's the next step above that.
So let's also talk about depositions, because that's another one that sort of floats around in this also.
Mm-hmm.
So tell us about depositions.
Okay, so go ahead.
Yeah,
the deposition. So the deposition is when you have to, again, notice, everybody has notice, you notice the other party to sit down and ask them a series of questions under oath with a court reporter, and they take a transcript of everything that was said and done during that time. So it's an opportunity for you to work with your attorney, and they come up with a series of questions. If there's something specific that you're after, a particular issue that you're dealing with, then you would depose it. It's usually money or children. More so money most of the time. Then you can depose that person and ask them a series of questions. Then you get that transcript, and then and both sides can do this. If one side gets deposed, the other side can then depose. Then you get to read all those questions. They go through the transcript, and that then becomes evidence as you go towards stage 3 of your divorce process and trying to either negotiate a settlement or going to trial over it. That gets used as evidence, and anything you receive as discovery is used as evidence. That's how you get your evidence, because there's a code of evidence. So you can't just go pull a piece of paper out of the trash and say, here it is. I mean, there's a way you have to show the court how you got things. So discovery is that way of getting that, and then you can take that information and use it to bolster your case, or to provide to the court as evidence to show whatever it is you're looking for.
So discovery is like a verbal record, but it is transcribed by a court reporter.
A deposition is a verbal record.
Deposition. Discovery is more written, and you're maybe handing over records, and you respond in a more of a letter fashion.
Well, it's all part of the discovery process. I think that a deposition is oral, and form interrogatories and demand for production of documents is more written. It all actually just falls under the discovery procedure, I guess. But yeah, a deposition is an oral way of doing it, rather than sending somebody a document, because there's other ways of getting written responses from them too. You can get what's called a request for admissions, is another form of discovery. Rather than doing a deposition, you can ask a series of questions where they have to write, yes, I admit, or no, I don't, or admit this document is your bank account, whatever it might be. So there's written discovery and there's oral discovery, and the oral is the deposition. That's the way you actually sit and get to verbally pose questions to that person. Most of the rest of it is written in by way of submitting a document, making certain requests for certain documents or certain answers to certain questions. So one demands documents, one demands responses to questions. So you can do both. And there's a process and a time period for that. And that the closer you get to trial, that cuts off. So stage 2 is the time that you want to do all of those things, because then you can take that information as you go into stage 3 to formulate your negotiation and how you're actually going to separate it. I look at it as stage 2 is basically figuring out what all the pieces of the pie are, so you can recreate the picture and know what it is that then has to be divided.
Mm-hmm.
That's what it is. Getting a full picture of what you guys had when you were married, so that you can equally divide it so it's fair. Because if you don't know what it is, you can't divide it.
Yep, that's exactly right.
That's basically stage 2. It's the discovery. The whole stage 2 is basically a discovery process in and of itself. You're discovering what you had or what you didn't have, but in most cases.
And there's a bit of negotiation that goes probably back and forth once you do have it. The onset of,
in all honesty, starts too soon, and from my desk, from my perspective.
Okay.
I think people start to negotiate when they're separating.
Yeah.
I'm going to take this and I'm going to take that. And sometimes
We're going to sell the house and then we'll split the money from that. And then wait a minute, there's nothing else to then balance out the rest of the portfolio.
Correct. And that's a
I mean,
huge,
huge mistake. And
huge. And I'm sure you all the time too. It's exactly. And I always tell, don't do anything. Most people have but one pot of money, and it's either retirement or the house. And it's usually not both. And sometimes it may be, but that's where the bulk of people's estate is. So once that's gone, there's nowhere else to get money. And chasing money, getting an order is far different than collecting on an order. And your attorney, your family law attorney, will get you that order, and then they're going to withdraw and they're going to say bye, and you're going to have to go collect on that order. And it's very different. So make sure that money's there, make sure you have access to it, and it's all tied up before you do that, because
that's very important.
Very.
So we can touch point on, there's so many things financial as well, but when they're in this state and they're going through the marital home, as you mentioned, is such a huge negotiation piece of it. But then there's like marital portion. And I've read this, and I don't know, and apparently it's the share of the pension that's occurred during the marriage. So there's, and I know that they've highlighted it as marital portion. Do they still use that as on the forms, as everything? Like, is that still?
Well,
what is part of the marital portion?
Well, this is probably more in Heather's lane, really, but for the marital portion is that which was incurred during the course of the marriage. So then they have to take that and determine what the value was during the marriage, and then of that full value, a portion of that, a half of that, what your portion of that marital value is.
Okay.
And then they take into account ages, how, it depends on the type of retirement plan. All those things happen, quite frankly, post judgment, because you get your judgment and it says you're going to get you're going to get your interest in the retirement. That's what your judgment says. Again, an order in collecting. So now you've got your judgment, that your attorney got you your judgment. You're getting half your retirement. Bye. Okay, so now I have a judgment that says I'm getting half my retirement. Now what? Well, now you have to go get what's called the qualified domestic relations order.
Right.
To actually get your portion of that. And then there's a whole formula and calculation that goes into that. So when you're doing your negotiation, you want to get the valuations of what your portion is of the retirement plan, so that you can determine whether, number one, do I want that because that's tomorrow dollars, not today dollars. What do you need? What's that worth? And that's what those valuations come in, what your proportionate share is. Your side, your 50%, your one half, how much is it worth? And how much is it worth today? And in a retirement plan, you don't get that today. So it's not today dollars, it's tomorrow dollars, which is different than dollars. So people often look at short term and don't consider the long term. And then they they do it all. And then, oh no, excuse me, what did I do? Because they don't think about it till afterwards.
Right.
While you have to look at short term, you also have to consider long term, because we're not just living for tomorrow while we aren't. So there's a big picture and a little picture, and you have to consider all of it. And that's where that is proportional. So you have to figure out how much is your portion during the marriage, and then how much is that worth? And then what is the value of that? Because it becomes negotiation. Maybe you want the house instead of the retirement.
Yeah, I have people figure that out during their cases.
Yeah.
I would never let one of my clients go get a judgment without knowing what those numbers are. Is it even splittable? Can you actually roll money out? Every plan is unique. I mean, that's a whole other conversation. But the key piece of that though is you will hear the word QDRO, QDRO in it. That's the acronym. It's Qualified Domestic Relations Order. And the idea behind it is that you can't go gift out half of your retirement at any given time without it going through a tax affected transaction. So this allows people to split qualified retirement plans without that tax affected. So you can set it up and Jane Smith's name and John Smith's name, even though Jane Smith earned it all, he can now get half of it. And so it can be rolled over and he can then manage it going forward. So that's the key. And it is an order you submit, there's professionals, particularly here, that create QDROs, and it
And
usually
that's all they do. That's pretty much
that's all they do. And I always tell my people to go there because it is very technical and it's a huge source of malpractice for an attorney that doesn't normally do it. Like, I would always want you to go to a specialist in this area.
Yeah, and I caution you, quite frankly, to an attorney that just says they will do it, because most good attorneys that do family law, they don't do QDROs.
No.
They don't. They send them to a specialist, because some QDROs are one shot and done. Military QDROs and things like that, you have to be, you got to be on your Brown formula, and you have to have it right, or your SOL. And a lot of them are like that.
I would tell you to do a military specialist for military retirement, and which, I've got great resources there. And then I would tell you need to do another, just the financial QDRO specialist in that area.
And I wholeheartily agree with that. I do the same thing.
So that's a QDRO. You'll hear attorneys throwing that lingo around. Now the other one that there's two other things that people talk about on like if you can't solve some issues, like you can solve 75% of your issues, there's something called a bifurcation.
Right.
And like I had early on, like several years ago, I had a case that I had no idea. I'm like, what does bifurcation mean? Like, and what, like, the attorney's like, we can just bifurcate that issue. And I'm like, what does that mean? I'm like, okay.
It's like, wait, I thought I was doing family law. What is that?
Okay. I'm like, I took Latin. I'm like, oh.
Right.
So tell us a little bit about bifurcation.
Okay. So bifurcation is to separate out into two. So you're separating your issues into two. What happens is you're terminating. A lot of people want to just be done because they want to remarry. They want to get on with their lives. So they will bifurcate and terminate the status and what's called reserve on the remaining issues. So the issues that no one can agree on, they agree to what's called reserve on them, meaning the court still has jurisdiction and they still have to figure them out, but they're taking status and terminating the marriage and getting divorced, while they're then going to deal with all the issues of the marriage, the property and the kids and things. However, there's always a caution when you do that. Definitely seek legal advice before getting a bifurcation, because there are ramifications to that, especially if you're the one that carries the health insurance. There's big ramification, because you're still responsible for the other party until the marriage is done, until it's complete, until you reserve done. So it's really important, if you're going to bifurcate, get legal advice first. Absolutely. I mean, there's
sometimes that marital status is what is holding your feet to the fire to get the whole thing done.
Correct.
So suddenly you chuck that asset or that issue out, then they're like, oh, I'm already divorced, I'm not going to bother with the rest of the financial stuff.
And it happens a lot, quite frankly, because there's no pressure. They just don't deal with it. You also, if you're the party that's covered under health insurance, you're going to lose your health insurance. I mean, so there's a whole lot of there's a lot of ramifications. There's a lot of legal intricacies. So, I mean, I always caution, just at least get a consultation, do something, seek legal advice before you proceed. Now, it's not something you can unilaterally agree on, like anything. An agreement is two people. So if you do want to bifurcate and the other party doesn't agree, that's when you have to file the RFO, or request for order, and ask the court to bifurcate, or you guys can agree. And then there's certain things that you have to sign off on and waive when you do bifurcate. So again, I'm going to caution you to talk to an attorney before you just decide, oh, let's just terminate and then do the rest. Because again, just to make sure, just so you know what decision you're making. So, yeah. But that is to separate it out into two, so you can be done if you want to remarry or something like that, and you just need to be done for whatever your reason is. You bifurcate.
Yeah.
So separate it out.
And once the settlement is done, and you do have one, and I know that's referred to as a MSA, right?
That's the marital settlement.
Marital settlement agreement.
Yes.
Now, with that, is that set in stone or is it an MSA? Can it be changed? Can it be revisited? Because that's something, if there's children involved or young children involved.
It's a good question.
Mhm.
A judgment is a judgment.
Okay.
Caveat that with children are ever growing. So, and when with support, circumstances change. So if there is a change in circumstance that warrants a change in the judgment, you can file a request for order with the court to request that they modify those orders.
Okay.
Property, things like that, consider it done. I mean,
No.
unless that's a whole
Financial, done.
done. All the
Mhm.
financial stuff, it's done. You can't revisit it, or what's the point of a judgment?
Right.
If the kids change, if somebody moves, if a job changes, if your circumstances change, you remarry, you can revisit those issues again. You have to demonstrate a change in circumstance. Now with the kids, the change in circumstance also, it's number one, it has to be figure out how your judgment's written too.
Okay.
And then it also has to be in the best interest of the children. When there's a change with the kids, it's always the best interest of the children first. So, but you also have to then demonstrate, again, a change in circumstance. You can't just say, oh, you know what, I've decided that I want every weekend, and your spouse says, no, I want still week. You could go in and ask for it, but chances are that's, unless you demonstrate a reason why, if you've already been doing this and it's been working and it's post-judgment, unless you show them a change in circumstance and a reason why it's in the best interest of the children to change it, just because you feel like it.
So it's not an easy thing to do, is what I'm trying to say. Okay.
Post-judgment ball game. It's a lot harder. Your burden of proof and what you have to go through is much harder. Most 8 out of 10 times they're going to punt you out to some kind of an evaluation. You'll hear a 3111 evaluation or 730. You'll hear those terms referred to. Custody evaluations. So that means they're sending you out to an evaluator to go through a series of questions, and then they'll make a recommendation to the court, because judges aren't going to sit up there and look through your stuff and go, okay, this is what I think. They're going to depend on the expert. So that evaluation is your expert that's going to assess your situation and make a recommendation to the court.
So let's bring another definition in here. So because most of my cases end up with a vocational assessment.
Yes.
And that is done by an expert, typically paid for by the person requesting it.
Yes.
And it is, people are always like, he's asking for a vocational assessment.
Yeah. So that is an assessment to figure out how much you're capable of earning, what your working skills are. That is always, those always come into play when support obviously is an issue, and a person's ability to earn a living. How much can they earn? This person's saying, I need to, and this is a lot of times in long-term marriages where marriages over 10 years, where you're looking at long-term support. And maybe one spouse has worked or they're getting on their feet. There's a million circumstances, but for whatever reason, they're not earning their potential, or the other spouse thinks they have a potential to earn more money. So they put them through, they request a vocational evaluation. This vocational is work, evaluator sits down with you. They go through what your skills are. It's a comprehensive evaluation. What your skills are, what your resume is, what your work experience is. Then they look at what the jobs are out there and how much those jobs pay and what you're capable of earning. And then they will give the court your low, medium, and high earning capabilities. And in most cases, what happens with that is they turn that over to the court. The court will pick the middle ground, and there's another word. This is called, they will impute, which means they will say that the other party is capable of making $50,000 a year, even though you're only working at McDonald's because you're making $9 an hour. You quit your job so you don't have to pay support, but you were making 50. I'm just gonna to say you're making 50 and you're going to pay, the court will impute you at 50 because this vocational expert said you can make, the highest you can make is 75, your mid range is 50. So we're going to base your support on $50,000 a year. And even though you're only making $9 an hour, you still have to pay support on 50 because you're capable of making 50,000 a year. So that's what a work evaluation is. It shows what somebody is capable of earning. It demonstrates to the court by an expert what somebody is really capable of earning, rather than just a spouse going, well, because a lot of times, people will change jobs, they'll quit jobs, they'll lower their income, or circumstances change.
Mm-hmm.
So, they went from making $130,000 a year to $9 an hour. Well, you're capable of making, this is what you made for the past 10 years. And this is what's out there for that kind of job. So we're just going to say you make, and I'm using a big figure. But that's what the point of it is. It's to prove what somebody can earn.
I had a case where someone quit their job as a CEO and got a low paying job and then got imputed 250,000.
Yeah. It happens.
Yeah, it happens. I mean,
people tell me that all the time. I say, you know what, every time he says he's going to do this, he's going to, good luck with that. Like, this is not their first rodeo. Do you think he's the first person to say that? I promise you, get in line. They've all said that. It's not going to happen. Well, go ahead and quit your job. You're still going to owe the money. And at the end of the day, they're used to living on that income too. They don't want to be in poverty level either.
No.
They have bills to pay and stuff too. So the reality is they're still going on with their life. So it does happen, but it doesn't happen for really.
Yeah, most people don't do that.
No. Exactly. Those are the extremes, but it does happen because I've seen it too. But people threaten it all the time.
They do. It's part of the strat. We can have a whole conversation about strategy. So you're not surprised by some tactics that come out. So a couple other words that I think are important early on when you're just getting your feet underneath you are things like pro se. So there's people who want to just represent themselves. Are you pro se? And that's all that means. Like, are you represented or by an attorney, or are you going alone?
Yep.
So just, that's a word, and it's all over forms. It'll say, are you pro se?
Right.
And that was that's kind of a funny way of saying that. For yourself is what it means.
Yes.
The other thing that is in higher conflict cases are things like minors counsel, or, so walk through some of the terms of some of the experts that are out there that represent the kids in the case. A lot of cases, most cases, you don't have to have someone hopefully involved, but sometimes there are resources like a minors counsel.
Yes. That's when there's those are really high conflict cases, high conflict custody cases, and where they've just gone back and forth a lot, and the kids actually need representation. And it's sad because at that point they need protection from their parents is really what's happening. They can't figure out who the bad apple is by that point. So then the party that has the ability to pay, what they do a lot of these times is they make the one person pay and they put it as subject to reallocation, which means they'll figure it out later. But then they have an attorney that's appointed that represents the minor. So minors counsel actually represents the minor child, and they're there to protect the minor child and their best interest, whatever that may be, even if it's against what the parents think. So that way this child has a voice and can be heard and is protected. And they're not necessarily just listening to what the child says. They're looking to see what's really happening. They're getting in, they're meeting with the psychologist. Many times there's a CPS in a lot of these cases. They're dealing with those type of issues. So they really
tell them what a CPS is. There's so many.
I'm so bad. I apologize. Here we are doing lingo and I'm using it. Yes. You don't even think about it. Child Protective Services. And can I just, before I go on, I want to caveat people, because people think that when something goes wrong, I'm just going to call Child Protective Services because it's a weapon. They are not your friends.
No.
They are professional baby stealers. They are not there to help you.
Nope.
So they should not be your first call as a strategy to piss off your spouse because it will backfire. So that said, that always gets under my skin, because I think it's their role is so misused and misguided. And I'll leave it at that.
There's a lot of really sad stories.
I 100% agree with you. And so I don't think it's a strategy. I don't think
It isn't. So it is sad, but because there are kids that need them. And I think that the kids that actually need them get lost because the ones that don't need them.
They're wasting the time and resources on
Right.
Exactly.
Right.
What about a parent coordinator? Then there's like all these, there's parent coordinators, parent alternative, PAR, alternative residents. I mean, there's quite a few that go in there, but a parent coordinator?
Well, I mean, in all honesty, we don't deal with those. I rarely come across a parent coordinator.
Right.
More so, it's probably you're like more a divorce coach or a mediator or a third party person that's able to coordinate between the two people. From the legal perspective, most of the times, that comes in when you have supervised visitation. So we call it a supervising supervisor. So it's probably the same thing. It's somebody's visitation needs to be supervised because somebody really just doesn't know how to behave themselves. Right. And so they have a court order for supervised visitation. So at that point, you have to coordinate with that supervising monitor when they're going to be there, what time are they going to have visitation, and then they'll write a report to the court,
right,
letting them know how that visitation went, whether they showed up, whether they were engaged with the child, how they behaved with the child, whether they were on drugs, whether they showed up sober, because usually those kind of cases, it's sad, but that's what's going on. There's either, it's most of the time it's drugs, because when there's issues of abuse, they may not even get that, but issues of abuse, drugs is when it happens. So they just make sure that the interaction is safe, that the child's safe, because it's all about protecting the children. It's always safety first with the kids. And so that's what that's all about. So those are when, again, those high conflict cases when you need somebody to just monitor the custody of the other party.
So there's so many things that we could talk about within it. What I did remember is, I don't know if we actually touched point on this, but before you have an MSA, right? The marital separation agreement, there is just a separation agreement that could happen before your divorce actually happens, right? It's in regards to supporting a child.
Oh, well, okay. So you're talking about, okay, I apologize. Yeah. So you can enter into a stipulated agreement. Yes. A stipulation in order. Okay. Yeah. So what you can do is you can agree on issues in between and sign what's called a stipulation in order. Like, okay, let's get these issues out of the way. I know that I need support and I'm going to stay in the house and for this amount of time. So let's make an order that I'm going to have Jane and John Monday through Friday, and you're going to have them every other weekend, and you're going to pay me this. Let's go ahead and prepare what's called a stipulation in order, and then they can sign that. It gets filed with the court. It gets signed by the judge. That's now in order. Now that's off the table. We can revisit it when we're putting everything in a bow, we're packaging everything up. We can either incorporate it into our settlement agreement, and all that happens in that stage too.
And they could be temporary support orders, or
all of the orders are temporary until that pendente lite. That's all temporary until you reach a final, until you have your MSA and your judgment. It's all temporary. Once you have judgment, then that's your final order, your divorce decree, your judgment for divorce. Anything after that becomes post-judgment and a different ball game. But before you actually reach your, before you sign your settlement agreement or go to trial, everything in between all those orders are temporary. They can all change. So even your stipulation in order, everything that you've signed in between, they're all temporary. Now, it doesn't mean that they don't roll into your permanent orders, because that's what happens a lot of times. You've agreed on it, it's working, you just roll it into there. Or maybe something's modified and you have to revisit it at the time you're finalizing things. But yeah, you can actually put those things in place and agree. And that happens a lot. Take it off the table, because then it's less to fight about. You know that you agree on this.
Well, they're living in limbo, and children are living in limbo until the divorce happens. As you know, there's so many things to negotiate before then. So,
so usually, important. Come up with some kind of custody agreement or file your request for order, just to get some kind of guideline in place for custody support, those type of things, until you can get to stage 3, which is where you're negotiating at that point. And it just depends on how you get there, whether you're working together, whether you're working with a collaborative, someone to help you collaboratively, the two of you together, a mediator, a divorce coach, a financial planner, a CDFA, a LDA, however you're getting to your mediation or to work together, the two of you together, or you're doing it with attorneys, you know, one way or the other, the forms and the process is the same. It's just the emotions and the back and forth in between.
That's the
and
hard
the game
part.
that played, the he said, she said, the blame games, the hurt, the anger. It's those things that cause divorce, number one, to be so expensive and take so long. It's the emotions. It's not necessarily the process. So then by stage 3, at some point, you've probably had some settlement negotiations or talks, or you have an idea. You should have all your numbers. You should now have your discovery. You should know what you're working with and be able to either send a settlement proposal over to the other party. If you're unable to settle, you can file what's called a request for mandatory settlement conference, which is a precursor to trial with the court. Requesting the court, it's a formal settlement conference is what it is. A lot of times people will have what's called a 4-way, which is another term they'll hear is a 4-way, which means that people are sitting. When I first came into law, I'm like, what the hell is a 4-way? I don't know if I want to know what that is. Or they'll do 3 ways. And that means the 2 attorneys and the 2 parties are all sitting down in a room and trying to hash it out. That's what that means. That's what a 4-way is. And it happens a lot. It's a way of trying to settle your case. It's like a mediation. So if that doesn't work, then, and you need the judge to kind of step in, and you feel like you're not getting anywhere, and you're at that stage 3, that's when you would file your request for mandatory settlement conference, which gets you into the court. It's basically preparing for trial. They're called an MSC, is what you'll hear that. It's a mandatory settlement conference, and they're referred to as MSCs. And you will hear about those if you're working, with your attorney through your divorce process. At the MSC, though, the judge makes recommendations, not orders. So it's a formal attempt to try and settle the case. If there's an issue of contention, the attorneys can go into the court and say, hey, judge, this is what we got going on. This is where we're stuck. And the judge will make some recommendations, either as to how the parties can try and settle it, how he might rule if the parties decide to go forward on that issue, and where his thinking is on that. So then, because the courts want you to settle your case. They don't want to have to make that. Those judges don't want to make that call for you. They want you to figure it out. Yeah. They're supposed to be your last resort.
Yes, it's in your best interest.
They give you recommendations. They'll give them recommendations. And quite frankly, if anybody's ever been to the family court, most things happen in the hallway. If you actually make it inside the doors to where the courtroom is, you're progressing along, because most everything happens right out there in the hallway. Everybody's running out, and then they make their agreements, and then they bring it in and they'll get it signed. So a lot of times the MSC, because it's a precursor to trial and you are turning in so much paperwork, you're preparing for trial, your cards are kind of on the table. A lot of times things will settle then, because it is that pressure, that foot held to the fire to say,
Plus,
hey,
you've got a judgment statement. I mean, you've got some judge helping you, which is really.
And the next step after that is trial.
Right.
And then your attorney's looking at you going, okay, if we're going to go to trial, you're going to pony up another $10,000, $15,000. And then, oh, well, wait, you know what? That bet is not so important anymore. Perspectives change.
Way more than $10,000 or $15,000 a day.
It is. When you're going to trial, it absolutely is. I mean, that's just for the day of trial, quite frankly. Going to trial is expensive. 10 or 15,000, you're lucky you get to your MSA or your MSC, because it's trial prep to prepare for your MSC, especially now. I mean, and there's sticklers about it now here in Hemet too. We used to be small town. We're not small town anymore. Certain courts are, and it's the truth, and that's the truth about courts. Certain courts are more sticklers than others about procedure. I mean, you have to follow the procedure, but some are the big downtown courts. You have to be on it. If you don't dot your I, they're going to send it back.
Right.
In a small courts, they're like, oh, they didn't dot their I. Let me put the dot on that for you.
Yeah.
And it's true. And that's just the real reality of how it is. Or you could be like, hey, you know what? She didn't put the I on there. Could you, Susie,
Yeah.
can you do that? Put the I on there? And they will. That's where your divorce professional comes in handy, because they know the people at the courts, and you can
Like they can
kind
call
of help facilitate those delays, because all it is a delay, because then it comes back, you got to do it and then send it back. So it's not doing anything other than avoiding a delay, you know. And it's what would happen at the law office too. That's what happens. Oh,
Jodi,
shoot, I didn't give you this for.
Jodi, you have really given us some great insight, because I mean, my head's even spinning sometimes. I forget. I mean, there's so much, there's so many, and I know, I remember looking up one time, I was like, oh, just for, you know, some kicks and giggles and whatever. I'm like, let's just look up all the divorce terminology. And it's like a database of so many words that you just, I don't even, I mean, didn't even come across, but I know they're there, and I've probably read them, but you're so emotional. You don't even read half of the things that are like, it doesn't make any sense to you. So, and you're hoping that your lawyer will explain it all, but it's so important to really get your head around these words and understand, especially the forms, and what shows up on them. So really thank you for taking this time.
Well, thank you.
We don't have any questions in the inbox, so we'll wrap it up, and you know, we're going to always have you back, because you're just a delight of information, seriously,
I
for everybody.
don't mean to go off left or right. I enjoy
No, it's
talking.
great. I mean, this is a candid conversation. This is what it's all about, right? So hopefully people took their notes, and have a little bit more familiarity around the processes and just the words and the terminology that are around it. Thank you, everyone, for joining. And this is Split.fyi. And you can find this video. It will soon be posted on YouTube, our YouTube channel. And you can also find us. Heather has the details for the Facebook group that we have right now.
FYI Divorce Support Community, a private group. You can always ask these questions in there. If you have a question, hey, my attorney is throwing around this word, why would we want to do that? Throw it in our group chat, and we're happy to, you know, break down the definition of the word and sort of where it fits in strategically within a case too.
Thank you.
Thank you.